So alternative dispute resolution, in its simplest terms, is ways to deal with conflicts outside of court. So this is when you have something that might potentially be a lawsuit or a legal matter and finding ways other than suing someone to deal with it. So that's what our general topic is, and this is not legal advice. We're not attorneys. We cannot give you legal advice. We're just talking about the general process, and there's a handout going around, and it's going to cover the 4 major areas of alternative dispute resolution. And what we do, who are we to talk about this subject? Well, I'm a paralegal, as I said before, and what that means is I work under an attorney's supervision doing legal work. So my business is I work for several different attorneys on projects in a lot of different areas of law. I'll do the work for them, research it, write it, whatever needs to be done, and then the attorney reviews it and actually presents it to the client or in court, and so forth. And then Alice, I'll let her introduce herself and explain what she does.
My name is Alice Shikina, and I mediate. So I basically take conflict, whether it's a litigated conflict or a non-litigated conflict, it could be neighborly disputes, and that sort of thing, or even landlord-tenants that are not necessarily in litigation. If they have a conflict and they can't resolve it by themselves, I come in as a third-party neutral, and I help facilitate an agreement. So that's what I do. So we'll be talking a little bit more about that, but that's basically what I do as a mediator.
Okay, and so, you know, everybody knows that as a culture in America, everybody loves to sue everybody, right? Like, that's what we're all about here right now. No, it's not what we're all about, but it is something that is, litigation is somewhat common in our culture here. And there are a lot of ways to resolve conflicts besides going to court. The average price to actually sue someone is usually at least, you know, $50,000 to $100,000 easily. So it's not really an option for most people in most situations, but particularly when you're a business owner and a small business owner, you're gonna have situations with clients, with vendors, with other people, plus, as Alice was saying, in your personal life as well, you can have situations where there's conflicts that need to be resolved. It's not happening. Nobody wants to sue anybody. What are some things that you could do to resolve these issues? So the first one on the list here, Alice is going to talk about, which is mediation, which is what she does.
So I also want to add on to something that Hope was mentioning. As a society, everyone is sue happy. It's also causing a burden on our court system. So I don't know if you guys know that, but courts usually are getting their budgets cut. So their hours are shrinking, so it's not even like a 9 to 5, it's like 9 to 3:30. And
in San Francisco.
yeah, and sometimes the court clerk office, they'll be like, oh, we're open from 10 to 2. So it just gets smaller and smaller and smaller. And so the judges really want people to resolve things on their own. So as we're moving into the future, 2020 going forward, ADR, the things that we're speaking about are becoming more and more popular, because the court system cannot handle the amount of lawsuits that are just coming in. So the judges are always like, please go out and do something else. Go mediate, go arbitrate, and that sort of thing. So we'll talk about that. So mediation is something that can happen at any point in time. It can happen when you just are mad at your neighbor. It can happen like when the lawsuit is filed. It can happen all the way till like a day before trial. Okay, and sometimes like litigated cases have like multiple mediations that happen. They may mediate and then it's failed, and they try again a year later and it's failed, because litigation takes sometimes like 1 to 3 years is an average amount of time. So the advantages to mediating are that you have some skin in the game, you have some say-so, right? Because you are at the table and it's basically a negotiation. We call it mediation, but you're negotiating with someone else in there, mediator, right? So you get to say what the outcome is, right? You and the other person work something out. So it's sort of a compromise. A lot of times you might feel like, oh, I really didn't want to give that much. But what a lot of people say is like, when the mediation, when both parties feel like, oh, I gave a little too much, that's sort of a good outcome, because everyone has compromised and you've given in something. The other thing that's good about mediation is it's far cheaper than the $50,000 to $100,000, okay? So it gets done a lot quicker. You're gonna get done with a mediation in a matter of several hours, as opposed to 1 to 3 years. right? And so you can just sit down and talk about it. However, the con with mediation is that both parties have to agree to mediate. If you have someone causing problems, and let's say it's not even litigated, let's say your neighbor's playing loud music, and you're like, we can't talk, we're fighting, I can't approach them. You can't even sit down at the table to mediate if the person playing the loud music says, no, I have no interest in mediating with you, I don't want to talk to you. Then it's dead in the water. So that is one of the cons for mediation, because everyone has to be like, yes, we're going to go in together, we're going to mediate this, and we're going to come up with a solution. Yeah.
Yeah, another thing about mediation, one of the benefits is that it's completely confidential. So you don't lose anything by going to mediation except for the time and the money that you spend in the mediation. But you could, for example, go into this, dig down into the details and say, well, I'm willing to give up this if you're willing to give up that, and then it all falls apart. They can't hold it against you that you said, I'm willing to give this up for that. It's like, it can't ever be, you can't transfer over into a legal framework. So it's not a no-lose option, but it's a low risk proposition, and you might be able to resolve it all and reach an agreement and not have to take it further. Another thing about mediation is that, particularly in divorces, I've seen this a lot, you can still have an attorney representing you and helping you in the process. Now, the mediator is going to be neutral. Sometimes a mediator is an attorney, sometimes they're not. They're going to be neutral, but you can talk to an attorney before you go to mediation and say, all right, this is what I'm going to ask for, and the attorney can say, don't ask for that. A judge would never give that to you anyway. Ask for it, but if they won't agree to it, don't die on this hill, because you won't win that in court anyway, right? So you can go in with some knowledge of what you should be asking for, and you can reach an agreement and have the attorney review the agreement before you sign it and things like that to make sure your rights are protected. Okay.
If you're in litigation and you go to mediation and the mediation fails, you just go back into your litigation. So you don't lose anything that way. So if you're like, oh, well, I'm being sued, and if I go to mediation, does that mean if it fails, like that's the end of it? No, you just you get back in line to mediate, or to litigate. Okay?
Oh, and one other thing about the, one of the cons of mediation is if there's a really big power imbalance between the two parties. Like, for example, if it's a wrongful termination, like you feel like you've been terminated from your employer unfairly, they're not really going to meet you in mediation. They have no, or a situation like domestic violence. That's not, there's a huge power imbalance, and it's not going to work. It's not an equal playing field. So it doesn't work for every situation. It's more situations where there's a will to work things out. And then arbitration.
So the other thing is arbitration. How many of you, I'm just curious, how many of you guys know what arbitration is?
Besides the attorneys.
Okay. So arbitration is basically a private trial. Okay. I also do some volunteer work as an arbitrator, and so the difference between when you go to arbitration as opposed to when you go to trial in a public court system is that everything in the arbitration is private, therefore confidential. Meaning your papers, your life, everything is not out there, because every single time you sue someone in court, I don't know if you guys realize this, it's public. So any reporter, any competitor, any of your enemies can go and find out every single paper that was filed in the lawsuit. Okay, so just keep that in mind when you are going through a lawsuit. All of that will be public material. If you arbitrate, it's all the same sort of thing. The arbitrator is the judge, okay? And just like in a regular trial, there's a winner and there's a loser, all right? So one of the reasons why you want to mediate is so that you're not the loser, because if you go to arbitration, there's no splitting the baby, okay? They're not gonna be like, well, this middle ground is where I'm gonna, no. You either win or you lose, okay? And there's really no way for you to tell. Like if you meet an attorney that's like, oh yeah, you're 100% going to win, like you should probably fire that attorney, because that's just not the truth. The truth is like somewhere in between, and they can say, yeah, you have a good case, but no one can ever guarantee like what the outcome will be, no matter how good you feel like the case is. So arbitration works that way. It's private, it happens fairly quickly. With the court system being jammed up, they might give you a trial date like a year and a half down the road. Whereas you can say, no, we want to arbitrate, we're going to find an arbitrator, and like we want to hire them, and they have availability next month. So then you can do it that way, because you can just hire someone private. Okay, you'll pay a little bit more money, because the court system is not going to be the same price as an arbitrator. However, you're going to get it done a lot faster because you can just hire whoever's available and move forward. Okay.
And you can email the judge. I mean, like, it's just a different, you know, and people that don't normally go to court wouldn't understand the value of that, but man, you know, you can get things signed, you can get things moved. It's not this huge bureaucratic mess like going to the courthouse to deal with things, and 6 weeks later you might get the paperwork back. So it's a very different experience.
Is now a good time for a question, or is that, would
Sure.
you rather?
No, go ahead.
So I've been kind of turned off to arbitration, because it seems like in my experience, it's, the arbitrator is paid by the larger entity, and if it's a company or an institution, those who are in arbitration are at a disadvantage because it's the company that's paying them.
So it depends on your exact situation. Typically, it should be split. Mediation fee should be split by both parties.
Yeah.
Arbitration fee should be
Most
split.
people don't have it. And so every time you sign off, and how many times do we sign off our legal rights to arbitration? And you have to. Now it's gotten to where you have to sign off to have a doctor, to have anything. And so we're just basically circumventing our legal system. And arbitration is not really equal in that it's whoever can pay.
I would say that I would ask an attorney to advise you on whether or not arbitration is a good
Yeah,
situation, because it's not there's not a universal right or wrong answer to it, and it depends on the circumstances and the situation. But yeah, it is a trend that binding arbitration for certain professionals to do work with you is part of it. But
Because they can
You do
pay,
have-
the institution can pay where the individual will likely not be paying.
you can't be forced to do
Yeah,
it-
but in order to
but
get
I mean,
the
but then you
service.
cannot do business with that person. Like,
It's becoming
It's
prevalent.
difficult because so much, go back and look at all the contracts you've signed from Comcast to
Yeah.
everything else. You probably agreed to arbitration.
yeah.
There are cases after cases after cases,
Yeah.
like class
It's
action
replacing
cases,
the system.
employment cases, where companies are forcing people to give up their rights.
Yeah, pretty
And
much.
so it's a gray area, but definitely if you find yourself in a situation where you feel you're being forced to arbitration, you wanna find an attorney who specializes in that area of law and see what the temperature is, because you might be able to get yourself out of it, because that company's looking at litigation, and your fact pattern might be the one that kinda tips them into the dark side. But yeah, it's bad.
Yeah, there's not a universal right, and that is a point about arbitration. Like everything in the world, the people with more money have more advantage. Yeah.
I mean, it's the same thing even when you go to the regular court
Of course,
system.
yeah, the person with more money has a better advantage. It's
Yeah,
But it's not as obvious.
So kind of in that, but you said in both mediation and arbitration, you can bring your attorney. Are they kind of like a consultant in that, or?
So yes, so with mediation, so it depends. With divorce mediations, attorneys are rarely there. They're there consulting, so you can call them during or afterwards to say, hey, is this agreement look okay? So that they're not billing for the mediation session. Or there are other types of mediations, personal injury mediations, where all the attorneys are there, and usually the defendant is not there, because the defendant has nothing to do with how much the insurance company is going to pay out, right? So they just are not there. So the plaintiff is there, and all the other attorneys, and the insurance agent is there in the mediation. And that particular mediation, they're usually in separate rooms. Whereas divorce, they're together.
And then that goes kind of, how is, like, say, mediation charged? There must be a lot less, but if I wanted a mediator because I was having a problem with my neighbor or something, do they charge me a flat fee, or
So there are several, for neighborly types and landlord type mediations, there are several nonprofit organizations, community boards here in the city, Seeds over in the East Bay, and they typically offer low cost or no cost mediations done by volunteers. So those typically don't show up to paying mediators because they have services that you can get for free.
Yeah, and I mean, some people will hire mediators for family conflicts and things like that as well. Like, there's staunch disagreement among the siblings about whether or not mom should go into this home or that home, or things like
I
that.
have a client right now who's getting a mediator because she and her youngest daughter are not getting along at all.
Yeah, and they need to make a decision. Yeah, so it can be used in a lot of different ways. The next area, was there more you wanted to say about arbitration? Okay, the next area is pre-litigation negotiation. So what this is sort of like a lawsuit, but not really. There are some attorneys that specialize in pre-litigation negotiation, and what that means is you hire the attorney, you explain your case and what you have, and then they're gonna send a demand letter to the other party and say, look, we're gonna sue you if we can't resolve this. And that can be particularly useful in situations where we're talking about the power imbalance, like in a wrongful termination case. I used to work in HR for companies. We wouldn't talk to somebody who had been fired and try and work out something with them. That's against company policy. But once they've hired an attorney, well, then they're gonna talk to that attorney and work things out. So it doesn't, and there are attorneys who will just represent you up until the point that you reach a settlement, or it has to go to trial, and then they'll turn it over to another attorney. One of the advantages of that is that you actually have an attorney advising you, and you're getting legal advice as you're going along. When in mediation, unless you hire an attorney, you're not getting advice, you've got a neutral person helping you resolve it. So your rights are being protected as it's going along. And in certain situations, when people realize that a lawsuit is possible, they're just more likely to come to the table. You've hired an attorney, you're serious, you mean it. And sometimes that's what it takes, is that letter and then a few conversations, and it can just be worked out at that point, because people try to call your bluff, basically. This can happen in a lot of situations with clients that aren't paying invoices, or things like that. There could be situations where it might make sense to get an attorney involved to work with you on that. Now, one of the cons is that they can just not negotiate. I mean, they might say, well, so what? Go ahead, sue me. I know it's going to cost you a lot of money. Like, they might not. It depends. It doesn't always work. And then one of the other cons is that it is probably going to be more expensive than mediation or something that doesn't, because you're paying an attorney for their time. But going all the way to trial is a heck of a lot more expensive.
Do you find in situations like with trust, you have a certain window of time before you can sue the successor trustee? You have 120 days per statute. So have you found or encountered a situation where either the opposing counsel is unwilling to either, have a tolling agreement in place to say, okay, we're gonna attempt this pre-litigation mediation, let's see it, and then if it doesn't work out, the other side still preserves that ability to sue, even though there's normally 120 days that you have to file that?
I have not been involved in anything like that, but
I can answer. Yeah. So I work with a firm doing some paralegal stuff with them doing that, and so they've got the statute of limitations, but we try to negotiate it all out before the statute of limitations is up.
Yeah.
So that if they have something that works for everyone, they basically sign it. They say, we're not gonna sue you guys, and then they deliver whatever it is that they want. So we try to leave at least a decent amount of time so that if negotiations do fall through, then they still have time to go ahead and file a lawsuit. So we try not to run that out.
and that's a
people wait.
yeah. And
yeah, they try.
Yeah, and that's a really good example of why in any one of these things, for the most part, talking to an attorney is a good idea. Because there are things like this that you might not, you might just have to pay them for an hour of their time and to say, yeah, make sure you do it before 120 days. Get this worked out or don't, or, getting some legal advice at any one of the points in this process is always good. But you just don't have to go all extreme to lawsuit all the time.
But in also answer to your question, typically when the lawyer shows up, they may still drag their feet, but not as badly as when it was just the person alone.
Yeah. And then, is there more you wanted to say about pre-litigation?
And then in pre-litigation, people frequently ask like, oh, is my case good? It actually doesn't matter because it's pre-litigation, right? And so as Hope was mentioning, there's always like that threat of a lawsuit. And because of that, people will come to the table. Companies have come to the table multiple times in my experience because it doesn't matter if it's a bad lawsuit. If a bad lawsuit has been filed, they still have to pay attorneys to defend it, right? So if they don't want to do that, they'll still come to the table to negotiate. So it really is not a matter of the merits of your case in pre-litigation.
Necessarily, although it's always good to have a good case, right? And then the last one is small claims court, and that's something that a lot of small business owners are gonna find themselves utilizing, and it's one of the most accessible things that you can do if you have a dispute with someone in your business or in your personal life that involves a certain amount of money. You can just go to the court's website and you can do it yourself. It walks you through the process step by step, and it's very easy. It's very inexpensive. It's $30 to $75 to file, that's all, so it doesn't cost you much money. There's no attorneys involved. You can't, now you could hire an attorney to advise you, but you can't have attorneys show up for the hearing or anything like that. It's a really simple and quick process. It doesn't take very long, 6-8 weeks to get it on the calendar. Yeah?
What's the limit for small claims?
Okay, so it's 10,000.
10,000?
10,000, yep. And so it can be, and there are some, and the rules of evidence and all of that stuff, it's not like a trial. It's kind of like a mini quick trial. It's a very fast hearing, and the rules of evidence are not super complicated. It's not, anybody who's watched Judge Judy understands what small claims court is. That's what it is. Yeah, that's what it is it's just simple disputes for a few $1,000s usually, that kind of thing. You present your evidence. You have to testify. You have to show up yourself. You cannot send anybody else to be your representative in small claims court. You have to serve the other person, which sometimes is the hardest part about it because you have to have them personally served. So a lot of times there's situations where a roommate ran out on you and didn't pay their rent and that kind of thing. So you got to figure out where they are and then get them served by the sheriff or by a process server. So that can be one of the bigger obstacles. But basically, you just present your evidence, your information. The judge may ask a few questions, and then they rule.
I have a question. So if I want to sue someone who's in another state, let's say, how does that work? Do they have to come to California? Does it not work?
Well,
They would have to come to California.
yeah, they have to come to California. But you mean like small claims
required
court?
to come to California?
Yes.
Yeah, can you do
because-
telephone appearance in small claims court? I have no idea.
I don't.
You can in other courts, but
Yeah, because so a couple things. One, in answer to your question, so there is a mediation the day of the small claims in several of the courts. So if you go to the small claims on the day of your hearing, you have an option to mediate right then and there. So in that particular case, you were asking about if people can come. I've had people fly in from New York, and they're like, small claims, I'm coming in from New York, I flew in, so many people are coming in on small claims from other states. So they are showing up, they're not doing a telephone appearance.
okay.
What would be the downside if they don't show up? If they
They will get a default judgment against them.
So you'll win if they don't show up.
Yes.
You win, but you can't collect necessarily.
Right.
Yeah, and then being able to, and that's the other thing about small claims court. Being able to collect sometimes can be a challenge, but you at least have an order from the court that says they are supposed to pay.
Do you know if there's any advantage to being the plaintiff versus the defendant in small claims court?
I don't know. I mean,
Why would that be any different than any other?
I just was wondering, like, the default would seem like if you were the plaintiff, then the other person didn't show up, the default would be a reason.
But if you're a defendant and the plaintiff doesn't show up, then nothing happens, you're free to go.
yeah, then it gets dismissed the
Yeah.
other way
I
too.
think it could be the judges too, because I know I've had an experience that.
Judges are human. You never know what they're going to do.
Right.
You
That's
just
totally true.
never know what any judge is gonna do in any situation.
Exactly.
So that's why mediation or resolving things outside of court, you're in control. If you can resolve something to something you can live with, that, rather than putting your fate in the hands of another human who doesn't know you. In general, I think that's a better idea, but
So
that's
you
me.
sue the judge.
Yes.
serious.
No, I don't think
will
so.
just share, I've been to small claims court 3 times. I sued a client that didn't pay me, they didn't show up, I got a default judgment. It was a challenge, but I ultimately collected all the money. But the problem is I'm trying to collect X amount of dollars, and if there's not at least that amount in the bank accounts I knew about, then they get nothing. It's not like they take, if he owes me $5,000, this is when it was $5,000, if he owed me $5,000, and there was only $4,995 in the account, they don't take any, because they have to be the loan. So you may be meeting with them, you may be doing stuff there multiple times to finally get your money.
So enforcement is a,
Yeah, you're on your own to enforce it. It's quick and it's easy and it's cheap, but if you win, you still have to work to get it back.
I've also sued 2 landlords, one of whom we settled literally right before they called the case. And the other one, and this is where I blew it at mine, they brought everything but the kitchen sink. I mean, there were 5 people that were saying, well, it was such a wonderful tenant. Well, it's your fault that you left. But I realized I didn't do a good job of, I should have had a single page cheat sheet summary with all the case information on the front to hand to the judge to say, this is when I moved into the building, this is what they gave me, this is what the lease says, and because honest to God, they had all these bids for they wanted me to paint, they wanted me to clean the carpet. They in fact had it's 2 years later now, they haven't done any of that work. And I really just got this a couple months ago. But they have these bids to do the work. And it's like, and the judge finally got confused because they had so many reams of things that, but I got the bulk of it. I mean, if I was asking for $1,600, I got $1,300 back, so I was fine. That for me, that was a win. But they evaded service. So in this case, it was commercial. So once the process server has made multiple attempts, then you can do alternate service. I can't do it. But my husband walked into the office and forced this woman to take it out of his hand. And took a picture with his phone. And
Can I borrow your husband?
so part of it is just having and it can be anybody, just can't be you.
Can't be, yeah. Someone who's
Brave
18.
enough to walk in and, talk their way in and force,
Can they do mail service? Or no?
yes, except the problem is it's certified mail, so we
They won't
tried that to begin with and they refused.
Oh, they won't take it,
Yeah.
okay.
Yeah.
So, if they refuse to sign certified mail from the Superior Court of State,
Right.
San Francisco Superior Court, then that failed.
And just to mention, yes, you do have to collect the judgment yourself. Yes, it can be challenging. So you might say well, how does that help? Well, the other side, they get dinged on their credit. They may never be able to take a loan out. So really, if you're dealing with a super shady person that doesn't care about their credit and that's gonna be moving around and that sort of thing, it will be much more difficult. If you're dealing with someone who really cares about their credit, they wanna be able to get a loan, they wanna be able to buy their house, they're more likely to pay you. Because that stuff will adversely
that's
affect value.
public knowledge.
Yeah, and it's public,
Can
yeah.
you put a lien on their property too?
I don't think so.
You may
That's
have
a
to go through a
separate
whole
kind of
separate
thing,
thing,
yeah, there are ways to do that, but then
If you were to garnish it, usually that's in Superior Court, not Small Claims. But there's ways to get out.
yeah, and all this information, the court's website has a lot of these answers there for you in the forms, and we'll link to it for you so you can figure it out. And it's always a good idea to talk to I'm a big fan. It's expensive to retain an attorney for a case, but it's not terribly expensive to spend an hour or two with an attorney getting really good advice and recommendations and a plan when you're gonna do it yourself or do alternative dispute resolutions, because then it's sort of the best of both. You're getting good advice, but you're also doing it yourself and keeping costs low.
One more
So,
question?
yeah, I mean, I was, when I said, can you see the judge, I was absolutely serious, because when I bought my building, I was put in a dangerous situation by a judge who ruled in favor of a squatter in my building, because, and there was plenty of evidence to not rule in favor of the squatter in my building, who, by the way, had been squatting there for a year and a half, and, there was already a very long history of an eviction case, but the judge, he lied to some attorneys He lied to free attorneys who said he was good, like a senior, and he wasn't a senior, no one checked his ID, like all this kind of stuff. And then he got a stay, and I was stuck with this guy, and then he was threatening me, he was in my building, you know, and I'm like, I wanted to sue the judge for bad judgment. Like, I'm sorry, but why did you put me in this dangerous
I
situation?
think that's called
I have
an
an arrest
appeal.
record of that.
I think that's called an appeal, and there are attorneys who specialize in that.
No, but it's too late. I mean, I did. I appealed it and I won. I mean, but I still was stuck with this guy in the meantime. You know,
Yeah.
this was a very bad situation.
The justice situation is very perplexing sometimes, and it doesn't feel right a lot of times, the way that things go. It's hard. It's hard to understand when you're in the middle of something, and when you get in the legal world, sometimes things don't seem to make sense, but that's how it goes. So if any time you can protect yourself, the other thing I wanted to say about all of these alternative dispute resolutions, the best way to utilize any of them is to not utilize them, is to have good contracts with your clients and your vendors, have good practices for collecting up front, have good systems in place, and assuming that, you know, have good documentation, have things in writing, all of this stuff, because every single one of them, if you reach this point where you're using alternative dispute resolution and calling an attorney, that means there's been a failure at some point. So an ounce of prevention in your business and in your personal life is everything, and it's always worthwhile to get some legal advice from a business attorney like Rosellen, whom I hired for my business when I was starting my business, and I feel like I have pretty good knowledge of contracts and so forth, and I paid an attorney to write one for me, even though I do that all the time, because there are things that are worth paying for, and getting systems and legal protection in place before you need alternative dispute resolution is really one of the most important things you can do.
All right, thank